Yeah, dear colleagues, dear friends, dear participants here in this last session of today, I have the pleasure to give a presentation which originally had to be given or was intended to be given by my partner Ute Kilger, who is a real biotech specialist. But at the end of the day, very shortly, she couldn't come here, and then we decided to shift the whole thing a little bit, namely that Stefan, Dr. Schohe, took over what I wanted to talk about originally, and I took over the role of Ute. She should be here, but I give now this presentation here. But it is not so, as you will see from the accents I will present to you under this theme, Patents on Life in Europe, that there would not be my own opinion embedded in it. Ute might have in certain aspects a different opinion. Actually, I'm a patent attorney, European patent and trademark attorney, working in the same firm as Stefan does in Munich in Böhmer & Böhmer. Patents on life in Europe is an interesting story, and I think it is particularly interesting in a time where certain countries like United States, our friends across the Atlantic, have the Myriad case, have come to the conclusion, at least for the moment, that one better should not, for what reasons soever, allow patentability, give absolute protection to isolated gene sequences. We have heard about this already a lot yesterday. I don't go into any detail. And we're also in India, if I understand my Indian colleagues and friends correctly, there are discussions how far the protectability of genes or gene sequences, and I would like to focus on that, should go. Let's look at the approach in Europe. It is really like a criminal story to look into the whole thing. The European Union states, countries, member states, starting in the late 80s and ending with a directive 98/44 EC of 1998, had been struggling to come to any kind of an agreement with regard to the possibility to protect human genes or human gene sequences, whether in isolated form or not. There were two positions. Germany was strictly against an absolute protection of these kinds of, if they are, inventions. Britain particularly was fiercely in favor of the absolute protection. What came out was a very typical approach by the European Union, namely in the form of this directive of 98, which says in number 2 of Article 5, an element isolated from the human body, etc., genes or gene sequences, in principle can be a patentable invention, is eligible, even if the structure of that element is identical to that of a natural element, where for all patent experts immediately the question arises, wow, where is novelty here, etc. But anyway, it is in the directive. And there comes an interesting, and this is what I'm pointing at, compromise sentence, namely number 3. The industrial application of a sequence or a partial sequence of a gene must be disclosed in the patent application. Disclosed in the patent application? Where in the patent application? In a drawing? In the text? In the specification? In the claims? Question mark. It is so vague because, particularly between the two country players I have talked about, no agreement could be achieved, and they wanted urgently to clarify this problem before the directive came into force. Now what happened then? After that, EPO immediately, I don't know the English word for what we say, vorauseilender Gehorsam. I mean, without the member states like Germany having implemented the directive at that time already, and directives, just for those of you who are not familiar with that, are not regulations of the European Union which would have immediate law effect, immediate effect and direct effect as law in the member countries of the European Union. No, directives are instructions to the member states to adapt their laws in such a manner that they correspond to the directive. So a directive is directing, instructing the member countries, nothing else. EPC, in EPC 2000 already, took the directive one-to-one, and you see it here in Rule 29 of the European Patent Convention. There you find in number 3 identical wording as in the directive. The industrial application must be disclosed in the patent application. Again, what does that mean? Specification, claims, who knows? Germany read, from my viewpoint, a little bit more carefully the directive, again and again and again, and introduced in 2003. It took 5 years. Germany was already taken to the European Court of Justice for penalty procedures because Germany delayed the coming into force of the directive for 5 years and implemented in 2003 with an interesting reasoning when you look into the materials why they did so. By amending the German Patent Act, which then came into force in 2005 only, so it's only a little bit more than 8 years, that in case the subject matter of the invention is a gene sequence or partial gene sequence, wherein the structure of said gene or partial gene sequence is identical to that of nature, etc., etc., then its use has to be included in the claims for which industrial application has been specifically described. So Germany said it must be in the claims. Now, we have an interesting situation. We have a European Patent Convention, which does not say it has to be in the claims. We have a German Patent Act, which says it must be in the claims. I have, with some amusement, shortly after the coming into force, after 2005, of the German Patent Act, heard lectures by quite a few scholars in Germany and beyond that from now on you would be able in Germany to get 2 different kinds of patents. One through the European Patent Office, where you could get absolute protection for genes or gene sequences, and one, a national German patent, where you only would get the restricted use plus the gene sequence plus function plus the purpose, much more restricted. And so with the recommendation that you please should better file European patent applications because you would get a broader protection in Germany. I never have believed in that, and in the meantime the situation fortunately has become clearer. And you can read this particularly for those of you who like to read commentary books in the newest version of Schulte Patentgesetz, about 2 weeks old, where Mr. Mufang at the EPO, one of the great, I would say, legal philosophists in the technical boards of appeal and legal boards of appeal, has said that cannot be read differently in those things in the Patent Convention Europe and in the German Patent Act. It means all the same, namely it means that at the end of the day, you will have a valid patent covering Germany only with a scope of protection which is restricted to the use as described in the specification under EPC, and in Germany even contained in the German claim. The solution, if you would attack out of a German national patent, where the use is in the claim, by the way, if you would like to go against an infringer not using the gene for that purpose and with that function, would automatically be that you would, of course, be outside of the meaning of the claim. And if you discuss with judges of the 10th Senate, the arguably highest patent authority, at least in Germany, you will find this opinion as the general mindset of the judges, which say if it is not in the claim, if they would now have to decide on a European patent, the so-called European patent, German part of it, they would use an old German case law tension screw, Spannschraube, which restricted about 10 years ago the scope of protection of the, as given by the wording of the claim, in that sense to the meaning of the claim, which an ordinary man skilled in the art can derive from the specification, where you will say the word in the claim, what the dictionary says, does not play a role. you must read the patent, and if in the patent, in this case here, you have described a certain purpose, function, etc., that is the meaning of the wording of the claim, and in that case you are outside of the wording of the claim. And doctrine of equivalence, for many reasons, so I cannot talk about it. Here we have no time for this, cannot be applied in this case anyway. So one possibility for Germany out of the present situation is that, of course, both kinds of patents will not be useful to get the gene sequence protected in absolute manner. It is only for the purpose as described in the specification, at least as far as Germany is concerned. What other ways out does Germany have? We have compulsory licenses, of course, and this is the alternative in which the German courts, particularly the Supreme Court, could use the German law in order to avoid that a gene or gene sequence is in an absolute manner protected. I don't wish to talk about the ordinary compulsory license under German law, but we have an interesting compulsory license possibility in Article 24.2 of the German Patent Act. This was, interesting enough, introduced into the German Patent Act at the same time when the German Patent Act was changed to implement, in the sense I have described, the Bio-Directive of the European Union. And it says, the German legislator went even further than taking certain aspects insofar from the Bio-Directive, that they say, even without public interest, you can get a compulsory license under a patent if you can't get a voluntary license, which is dependent on an older patent, but that patent comes at a price. That license comes at a price. It comes at the price of a counter license, a cross license to the owner of the old patent. And this creates an ideal possibility to solve the problem of gene sequence protection in an absolute or not absolute sense. If you find, in other words, another function of a gene sequence which is protected by an older patent in an absolute form, according to the opinion of certain people, and you invent the use for a new function and you patent this, then you have something which is dependent on the old patent, but which you cannot exercise without, should the scope of protection discussion I just started a little bit earlier not function, which cannot be exercised without violation of the older patent. And in that case, the owner of the old patent, the former patent, the original patent, is subject to a compulsory license against the cross license from the newer patent. Public interest is not to be checked. It only has to be a important progress in a technical sense, whatever that may mean. We have no case law on this at all, but I can predict that if in future there should be problems arise, because the Federal Supreme Court would not choose the way to restrict also the protection scope of EPC-based patents in Germany to the function, that this would be the way out in which this paragraph all of a sudden could be woken up to life and could play an important role. This is the situation in Germany in a nutshell, different from many other scholars in Germany, and probably also different from what my dear partner Ute Kilger believes. I think Germany does not have absolute protection for human genes and human gene sequences. It is a function-related, a purpose-related protection, and that is good so. Thank you.